Alex here with a legal nuts and bolts video on the answer. Just like with in fact, you should watch the complaint. If you haven't watched the complaint, please watch it or this video is going to make very little sense to you. Just like with the complaint, the purpose of this video is not to go into every little teeny tiny detail with regards to how an answer works. I'm just trying to deal with the issue that self-represented people will often try to prove their case every step of the way with every filing. And it frustrates the courts, it frustrates attorneys, it frustrates the judges. And so, just like with the complaint, I'm going to try to let people know the very, very limited role that the answer has um, in a court case. So, the complaint opens the case up. It sets forth who the targets of the lawsuit are, and it sets forth what the issues before the court with regards to the lawsuit are. That's all it is. Anything that goes beyond that is usually damaging to the plaintiff or petitioner, whoever's filing it, and it should not be done. With regards to the answer, same thing. This document has, for the most part, three very specific, very narrow objectives. Its purpose is to just confirm to the court and the plaintiff the issues that need to be decided. That's it. And that's why the answer just contains, for the most part, a list of admissions and denials. If you have seen an answer, it'll typically go down the complaint's allegations, literally line by line, and it'll say admitted, denied, admitted, denied, admitted, denied. Sometimes it'll say something like denied for lack of sufficient knowledge, which is for the most part the same as a denial. It's just that the person answering doesn't really know for sure whether they can admit or deny that because they don't have enough knowledge about that particular allegation that's been brought against them. Don't try and explain yourself with every single response to every single allegation. That happens later on in the process. The answer's goal is to just let the court know that these particular issues are going to be issues that we need to address, and these other issues we don't because we admit them. Once you admit something, wonderful. Now that doesn't have to be brought up through discovery, it doesn't have to be brought up at trial, it's admitted. Um, and it's just a way to sort of narrow the issues that are going before the court. So the plaintiff has broadened the issues by listing who's being targeted and what issues need to be discussed. And the respondent or the defendant has narrowed down those particular issues by taking whatever issues that they can, setting them aside and saying these are admitted. We don't need to spend time and attorney fees and research on this stuff. We admit it. It's good. We're good on that. There are a couple of other things that can come up in an answer. One of them is affirmative defenses. My understanding is that those need to be listed because those are being sort of accepted by the person who's filing the answer as additional work that they're going to do to prove their defenses, which it sounds kind of odd to people because it is a little odd. For the most part, the plaintiff has to prove the case for the most part. All the allegations that are listed, they have to prove. It's their job. Most people who've even seen Judge Judy and all that, they understand that the burden of proof is on the plaintiff. Affirmative defenses are a sort of oddball situation, an exception to that general rule, because that is the defendant who has decided that they're going to limit their liability or they're going to raise as a shield certain things that, because of whatever issue or reason that the legislature or the law has come up with, they can do, but unlike everything else in the case, they have to prove it. So affirmative defenses have to be spelled out in the answer to give the plaintiff notice and to give the court notice that, hey, I as a defendant have decided that these 6 or 7 different special issues I'm going to use to shield myself, and I accept that under the law. I, as a defendant, have to prove it, which is not normally how it works, but with these particular specific legal doctrines and issues, for whatever reason, the law has decided you have to prove those things. For a couple of common examples are accord and satisfaction and duty to mitigate losses. So there are things that you can do. For example, you can say, yeah, the plaintiff is right about these particular issues, but I, the defendant, am asserting that under accord and satisfaction, I've already, resolved them because I have paid him off or we came to a deal. And because it's an affirmative defense, you are taking that burden. You're taking that, and you are accepting that you have to prove that particular thing to absolve yourself of liability. So, it kind of makes sense. Let's stick with that example. Say you hit someone's car and you came to a deal with them in writing, hopefully, because otherwise it's going to be hard for you to prove later. You came to a deal with them that you were going to pay this certain amount of money for that particular accident. Well, if they sue you later, they only have to prove that you caused the accident. You are the one that's going to take that burden of proof to show that you came to a deal or that you paid for it. It shifts to you for that particular issue because that's an affirmative defense. Whenever a defendant tries to say, I paid that off or we came to a deal, that is them affirmatively saying, okay, fine, I hit their car, court, your honor, I hit their car, but look, I paid it off, or we decided this would be the amount I would pay, and I paid it. So that particular defense is different from an ordinary defense. That's an affirmative defense. You have to list that in your answer as an affirmative defense, and the burden of proof, believe it or not, is on you to show that you actually paid those monies or whatever. The same thing with the duty to mitigate damages. So I hope that makes sense. That there are certain defenses that your opponent has to prove as the plaintiff, and then there are certain other defenses that are kind of set aside in a special category that you as a defendant have to prove, and those are the affirmative defenses. Oftentimes attorneys will just list all of them. They don't even know if they apply. You may see 27, 28, 30. I don't know how many affirmative defenses are out. There's probably like a website that lists them all. You can go ahead and check out those websites if you really want to. Oftentimes an attorney will just list all of them just because they don't know for sure which ones they're going to use. And later on down the line, a year or two into the case, they might find out, oh, we could use that affirmative defense and we didn't even really know at the inception of the case, but now having these years pass, now it seems to make sense to us that we can use these. So don't be shocked if you see 37 different affirmative defenses stuffed into an answer. They just don't know for sure which ones they're going to use against you, and so they're going to list them all. The last thing that sometimes gets put into an answer, as far as I know, it has to be if you're going to use it, is the counterclaim. And for the most part, the format of the counterclaim follows the format of the complaint, which is to just list a series of allegations against the plaintiff. And then those get dealt with in a similar format of the answer, but they just give it a different name and they call it the reply to counterclaim. In fact, I'm not even sure. I might do another video on that topic just to kind of keep this flow going. If anyone is curious, there are different names for, I guess you would call it a counterclaim-ish type of things that you do that are not against the plaintiff. So if you wanted to file a counterclaim against a co-defendant, that would have a different name. I think it's called a cross-claim. And then if you wanted to do something similar against somebody who hasn't been named in the lawsuit at all, that would be what I think they call a third-party complaint. Same thing as the counterclaim, just a different target, guys. So with the counterclaim, the target is the plaintiff. With a cross-claim, the target is a co-defendant. And with the third-party complaint, the target is just some brand new person that hasn't been thrown into the lawsuit yet. I think I may have videos on these other topics. Definitely poke around on the channel. If not, mention it down in the comments below, and I'll take a look into it, and I may create videos on those additional types of pleadings. But I do keep using that word, guys. If you want to, in fact, not if you want to, you should take a look at the video pleading, because in Nevada, a pleading is a very specific thing. It is not any old document that's filed in a case. That's a common mistake people make. A motion is not a pleading in Nevada. It's not. The Supreme Court has stated this many, many times. In any event, guys, I hope that this video makes sense to you. I hope that it just, that the limited role that it has, the answer has, is clear to my viewers. And I hope that, people see that there is a sort of logical undertone to this whole process, and that at different points in the process different things need to occur, and that the answer is a very limited document. And I'm laughing because a lot of people just don't know, and they get frustrated, and they just don't know what to do, and they get scared, and they think that they need to kind of cover their butts, and so they include everything that they possibly can in the answer. And attaching exhibits is, as far as I know, you're not supposed to do that at all. I haven't heard of any situations where exhibits get attached to an answer. There's rare exceptions for when they get attached to a complaint. For an answer, I don't think there's any at all. Maybe if they file a cross claim or a counterclaim or something like that, and one of those narrow exceptions that I discuss in the video, the complaint comes up, maybe then you would file some kind of exhibit. But for the most part, learn the process, guys, and understand that there's a method to the process and all that. So with that all being said, I'm going to go ahead and end this video now. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.